Pardon me. We're a little disabled today.
It's all right. Take your time.
If I could reserve 4 minutes, please.
4 minutes.
Your Honors, Mark Benfield with Shelby County and Davidson County Bars. It's an honor to be here. I represent Mr. Vitellaro in this matter, who, as you know, without reciting details of the facts you have, I'm sure, reviewed, fell through a skylight in a back shop or garage owned by a lady who he was doing some work for to clean out gutters of the shop, which was located adjacent to and next to basically a small forest of trees. And the defendant had hired our client to basically clean the debris off the front side of the building and clean the gutters, which contained, had been so neglected that trees were growing out of the gutter. When the plaintiff was having a difficult time cutting the trees from the gutter system with all the other debris, he had inquired, as it's in the record of the defendant, may I get on the roof to come and have to clip the root system? She said yes, and he says, and by the way, I normally have this bucket I'll scoop stuff when I'm cleaning the gutter systems with, but because of the nature of these trees, where can I put the stuff from the gutter system on the front side, all the limbs and branches? And she says, in the record, our client testified in the record, you can put it in the cow field out back, and by the way, any debris back there on that back side, don't worry about it, because that wasn't part of the estimate. And so after that testimony was elicited, and the rest of the medical proof and so forth was placed in the record, the defendants moved for a directed verdict, stating that under the law, the defendant would not have had any sort of actual or constructive notice that there might be debris covering the skylights that she owns on this property. And so the trial court, as you know, granted that. And looking at the order, it appears as though the trial court was granting that based upon an actual notice theory. If the court basically says the testimony that he was up there and saw it was 90% covered is not the standard. Well, additionally, she had reason to know that there might be debris on the backside as well. I mean, and I believe that she had actual notice because she mentioned the debris on the backside, and it certainly doesn't take a park ranger or even an arborist to see if you have 3 and 4 foot trees growing in your gutter system, then those trees contain leaves and branches, and you've got ivy growing across, and the roofing system that is of a building that is adjacent to basically a small forest of trees that have leaves on them.
Counsel, am I understanding the trial judge accurately, and set me right if I'm not, in that the trial judge, that 90% coverage that you're addressing, that is, the trial judge understood that as to be a comment on what he saw when he was up on the ladder. Is there anywhere in the testimony that he actually makes the 90% comment, which I guess pops up a couple different times, in reference to what he saw when he was on the ladder, as opposed to what he saw when he was standing on the ground?
I believe that since the plaintiff was also on the roof and on the ground, I believe that one would suggest that while he was on it would be based upon his entire observation of the entire roof and his experience that day. I don't know, Your Honor, whether or not there was a particular finding of is it on the ground or not.
He doesn't state anywhere, though, that I only realized how covered the roof was when I got up on the ladder. That's the point. And the pictures are taken from the driveway, taken from the backyard, that are showing the rooftop, right, and the exhibits that have been entered. So, and there's nothing in this testimony that said I only realized that it was covered when I got up there, right? It's not actually part of his testimony where he said I got on the roof and that's when I realized it was leaf covered.
No, Your Honor, and I believe that when you read his testimony, which you clearly have, and you've looked at the photographs, particularly, I would point the court to my favorite photograph, which is lettered as I in the record. As I understood and took the testimony, he was having a conversation with the landowner, the defendant, while they were on the ground. And at that point, she was having to show him what she wanted performed. And his observation, at least on the ground, was that there was, and in the record, is that there was limbs and debris, and the gutter system was full. And when he got up and he realized there were trees growing through the gutter system. So this is not something that was just, new to him. I mean, this landowner knew, had to have known, and that's why she called him out, that this shop building had been neglected.
And the constructive notice that the trial court didn't think the property owner had was leaves covering the skylights in the back portion of the roof, right? That's the piece the trial judge said, I don't think there's enough here for constructive notice on that. So if we are, is the trial judge then drawing a distinction between leaf coverage on the front versus leaf coverage on the back of that shed or structure or shop?
I think that's unfortunately exactly what the mistake was by the judge, is that the judge was essentially saying, well, you've got proof that there's debris and that the defendant knew the debris on the front side because that's why she hired him to come. But there's no proof that she knew there would have been anything on the back side of the property, which is not consistent with the trial testimony of the plaintiff that said, I was inquiring as to what to do with these large branches and stuff I can't put in a 5-gallon bucket. And she said, just put them off on the back side, but don't clean any of that debris off on the back side because that wasn't part of your estimate. So clearly the landowner either had actual notice that there was debris on the back side, or should have, and likely so, that it buttresses up next to a large forest. I mean, the photographs themselves, and the argument that the appellee makes of, we don't know how long it was here. We don't know how long those trees have been shedding leaves on this roof. Well, what we do know is that we don't leave our common sense at the door, and we know that what is in the gutter system is likely also to be somewhere on the roof. And knowing, by the way, that there is a skylight with a green rooftop is fairly hidden under those circumstances anyway. You add in addition to that it buttresses up to a forest.
In terms of timing here, this injury occurred in May, right? That's when this accident occurred. He fell through in the month of May,
Yes, sir.
not sort of closer to the fall or any other. So we're several months away from the fall when this occurs. Is that right?
I'm assuming, I have to be honest with the court, I was not the trial lawyer on this. I was brought in, and I started with this firm almost a year ago today, matter of fact. And I was supposed to have helped with the trial, but I had a similar injury last January for a similar situation. Fortunately, I can't sue my cat.
Let me ask it to you this way then. Let's assume for purposes of argument that it did occur in May, and that there's these trees surrounding, and they're depicted in the exhibits. Can we draw an inference from that if there were leaves covering the roof, that they would have been there for an extended period of time? This isn't something that happened in the days leading up to this occurrence.
Yes, and I think that's certainly exactly what a jury should be allowed to infer if they so choose. But the idea that there's no facts in the record to support a jury from being allowed to at least consider that option, that's why they're there. And so I think that's, Your Honor, primarily the problem here is that we didn't get to the point of having the finder of fact look at that and consider that to be an inference.
So would you say then that the evidence that a jury could find constructive notice, and it sounds like no question here you're arguing a constructive notice situation here, is the photographs, but on top of that, the fact that the landowner said don't clean any debris in the back. Those two together were a basis for a jury to find constructive notice.
And the fact that there were trees that were very large on
There was
on
a
the
forest
property,
behind them.
and growing into the property on the building itself. And so that tells you how long that the entire building had been neglected. And I'm not disparaging the defendant for that, but that's the fact of the case. That's what happened.
Okay, thank you.
Thank you. Pardon me.
Good afternoon, Your Honors. Corey Miller for the defendant and appellee Donna Goodall. May it please the courts. Ms. Goodall is a widow who lives alone on her property in Wilson County, and I would disagree with the scope of the work that counsel just stated on specifically cleaning off the debris on the front of the garage. There were text messages submitted that were part of the record, and there was actually testimony provided by Miss Lauren Hutchins, who's the fiance of Mr. Vitellaro, about the scope of the work. And the scope of the work was really to spray off the front of the garage and to clean out the front of the gutters. There's no dispute about that. But I would disagree there's anything in the record about the scope of the work cleaning off anything on the front of the garage, specifically the roof.
Counsel, would you agree that here there was a conversation between the plaintiff and the defendant about him being able to go up on the roof, and that would be okay? I'm not saying she warranted the roof or anything like that, but she knew he was going to be up on this roof, right?
So that is a disputed fact, but that was not part of the motion for directed verdict.
Okay.
As has been stated extensively throughout the brief, Ms. Goodall's testimony was not part of the record because for reasons unbeknownst to us, the plaintiff chose not to call her as a witness as part of his proof.
But the plaintiff did testify to what Ms. Goodall said to him.
And I believe I have the quote. I don't have the exact quote because there are some bracketed changed language in the quote from the appellant's brief, but the quote is, to worry about getting any debris on the backside of the on the backside of the building, because that wasn't part of the estimate. It says getting any debris on the backside of the building. That doesn't necessarily mean don't worry about cleaning the backside of the building.
In terms of the constructive notice that the trial court didn't think was present here,
Correct.
am I correct in understanding this as the trial judge looked out and said, well, I think there's enough here to show that the front of this storage or this building was covered with leaves, but not the back of the building. Is that the distinction the trial judge was drawing here?
I do not believe that's the case, Your Honor.
What's the distinction? Because there is testimony that 90% plus of the roof was covered, right, with trees. I mean, maybe that's right, maybe
Sure.
that's wrong, but I mean, we're a directed verdict. So,
Sure, I understand.
and so there's testimony that 90% of the roof is covered. So what is it that there was insufficient here for a basis for constructive notice?
So there are photographs submitted in the record that show the front. You can see the front of the roof, the front slope of the roof from the ground. You don't necessarily need to be up on the roof. Conversely, you have to be on the roof to see the back side of the roof, unless you were to go around. I believe there's some photographs submitted, but mostly the photographs that were submitted from the front or on top of the roof. What is missing here is, I don't necessarily believe that there were enough facts in the record to support a finding that Ms. Goodall had known or should have known about what was on the backside of the roof, because she specifically asked only for the gutters and spraying the front of the garage. She never asked about anything on the roof.
What I'm struggling to understand is that if the front of the roof is covered with leaves, and the testimony is that it was 90% covered with the roof covered with leaves, how is she not on constructive notice that those leaves are also on the back of the roof? And are these leaves that only fall on the front slope and not the down slope? I mean, it looks like it's all surrounded by trees from the exhibit.
So I don't have the specific testimony that you're referencing in front of me, but I believe the main complaint is the back slope of the roof was 90% covered. I don't believe I'm not reading that as 90% of the entire roof, because I've seen photos literally after. You can see, in fact, one of the photographs, you can see Mr. Vitellaro's blue ladder in the photograph. So it had to have been taken fairly shortly after, and there's not leaves covered the front of the roof. Her scope of the work was literally cleaning out gutters and spraying off the front of the garage. And so one of the things that one of the arguments that was made in the arguments for directed verdict is, and Your Honor picked up on it, is that leaves come and go. That was literally verbatim said by counsel. Leaves come and go, and they absolutely do. This happened May 28, 2020. We're 20 days, give or take, 21 days, 25 days from summer. Leaves don't fall in May. They don't fall in April. They don't fall in March. They fall in October and November. And as you said, as Your Honor said, are we to believe that leaves stay there for a long period of time? Leaves are light. They get moved around by weather. They get moved around by rain. And so really the fact of the matter is that the only person who testified at this trial who would have said anything about the apprehension of the risk for Ms. Goodall would have been Mr. Vitellaro, and his whole argument was that there's a big tree behind there and she knows leaves fall. That was the basis of their argument.
But there was also testimony that there was 90% of the roof with leaves. And did the testimony specify that it was on the back of the shed?
I don't think it specified either way.
Okay.
I don't believe that to be the case. But really, what we're here about today is the fact that...
Do we have to give the most favorable reading of that assertion to the plaintiff in this case, given that we're here on direct verdict?
Yes, and I believe Judge Collins did that.
Well, if we give it the most favorable reading, don't we have to read it as that that she would have seen that the front of the roof was was mostly covered in leaves also.
I don't necessarily agree with that
And
because.
why not? Why? Because I'll tell you, where I'm having the ultimate hang up here is if there's leaves all over the front, how do we not have constructive notice that there are leaves on the back? So how do we get to there are no leaves on the front in this case?
I believe the photographs show there are no leaves on the front.
And are those taken at the time of the,
They were taken shortly after.
okay.
I believe, and I do not have the exhibits in front of me, but specifically when you go through exhibits, I believe B through I, and those are photos. I'm going off memory, but I believe the photographs show they were taken shortly after there. That there's no leaves on the front of the garage.
So the photos weren't from 2022?
No.
Those are from the time of the incident?
I believe some of them were from 2020.
Okay.
I'm going off memory. I do not have the photographs in front of me. There were timestamps on them, I believe. But one of the things that I think is important is we do have a photograph where there are leaves on the backside. And it was after Mr. Vitellaro fell, but we do have a photograph of the leaves on the backside of the garage. And you see the leaves on the backside of the garage, and it was taken in January. But you don't see any leaves on the front side of the garage. So if there's no leaves on the front side of the garage in January, but there are leaves on the back side of the garage, are we to believe that the photographs that have been submitted, they don't show leaves on the front side of the garage in the summer or in the late spring and the summer? And that's when this really happened. It didn't happen in the fall and winter months when we have issues with leaves. We don't have issues with leaves in the spring or the early summer. So really, his testimony alone and the photographs were simply not enough to get to a jury on constructive notice. And I understand Your Honor's point is that the trial court does have to read the evidence most favorable in the light most favorable to the non-moving party, which would be Mr. Vitellaro here. But I believe he did that, and I believe he just saw there was no evidence in the record to support a finding of that he proved, or he showed enough evidence to show that a jury could find Miss Goodall had constructive notice of the leaves covering these skylights.
How many skylights total were they in the roof?
4, 2 in the front, 2 in the back, and there are two in the front, which again there are no leaves on the front. But I'm not trying to get into a fault issue. This is only about notice. We did not move for directed verdict on fault or Mr. Vitellaro's comparative fault as permitted or as we alleged in the answer to our complaint, but it's simply about what did he prove as far as what was his proof for notice. I don't believe they've made an argument for actual notice, although this is the first time today that I'm sort of hearing that from counsel. This is all about constructive notice. What did he know? What should she have known? And the argument that was made at the directed verdict hearing was really about the recurring condition. You know, the phrase "leaves come and go." It's recurring, but there were no Google Earth photos or no past photos overlooking the garage in the past to show there were leaves on the backside of that garage for years prior. If it's recurring, then it has to recur occasionally or recur over and over and over again. I believe that was one of the issues in the City of Franklin case. That was it was not a directed verdict. It was a bench trial, but the Court of Appeals affirmed the findings of the trial court in that bench trial, saying that constructive notice had not been proven because even with 5 or 6 years of Google Earth photos showing the rise in the concrete, that it was not enough to put the city on notice for constructive notice. One final point as far as the motion for directed verdict, I would raise, or sorry, the appeal for the order granting the directed verdict, is that they've now raised an issue about under Rule 50, that if there's been comparative fault alleged, that the trial court shall reserve ruling regarding the directed verdict motion. We respectfully submit that's been waived because the first time it was brought was at the appellate court level. It was not raised at the trial court. It's been devoid. The record is devoid of any argument to that. Even such, while I could not find any case law on that specific issue, respectfully, this is about notice. It's not about Mr. Vitellaro's fault. It's simply about what the facts of his case proved that Ms. Goodall knew or should have known about. And if he can't present facts in Tennessee in such a premises liability case, then he has no case, because you have to prove that a landowner had notice, whether it be actual or constructive, or if the landowner created. There's obviously no argument that the landowner created and put leaves on the backside of a roof and then told him to go up there and throw some stuff on the backside of the roof. And respectfully, Your Honors, we would just ask that that this court affirm the findings of the trial court and affirm the finding of directed verdict. Thank you.
Thank you.
To answer your question, I found that it's, at least in the trial transcript of the plaintiff, it's page 15, line 4 through approximately line 10, to give it the context, where he talks about when he was giving the estimate and says it was about 90% covered. If leaves come and go, I suppose there wouldn't have been a need for the gutters to be cleaned. The gutter system was full. The property had been so neglected that it was growing trees through the gutter system. It backs up to a small forest, and the idea to think that testimony, along with the fact that the defendant herself says, don't worry about that debris in the back or any debris that might be in the back, because that wasn't part of the estimate, that in and of itself shows that she is on constructive notice. There might be some debris in the back. If the poison ivy running across the roof and the 3 and 4 foot trees growing through the roof and the gutter system, and the bark and the moss don't do it, I'm not sure what else will. If I walk outside my home in the front, it's raining, I can assume it's probably raining in the back of my home too, right? I can assume if the closest part of this building is the back side, that's where the forest is, and the front side has all these things that it's full in the gutter, one would assume that the back side closest to the forest likely to have be more likely to have leaves and debris and ivy and so forth and so on. So I don't think there's any question, based upon the standard of a directed verdict and viewing the light and most favorable to the plaintiff's allegations in the complaint and what was presented at trial, I think there's any question that this should be reversed and sent back.
In testifying in connection with the exhibits in this case, I have a vague recollection, and I may be wrong here, of statements indicating that the roof was more covered at the time when the plaintiff is asked, and does this look like it looked that day? I have a vague recollection of him having said that it was more covered at the time than it was in the photograph. Am I remembering that correctly? Am I misremembering?
You are. You're remembering exactly correctly. There are some photographs, he says, this looks like it looked that day. That would be the photograph where you've got the ladder. Keep in mind that when that photograph was taken of the ladder, that wasn't taken, it was taken after the client had already fallen and after a lot of the debris had already been removed from the front of the place, right? He had already been cutting the 3 and 4 foot trees out of the gutter system. So, but yes, you're correct. Yeah, some were accurate depictions of what it looked like that day, and I think some of those were taken after the fact. Some were taken after he had done some of the work. I don't know when the others were taken, presumably well after, just to give an idea of what the shop looked like. I don't have anything further. Thank you very much.
Thank you. Thank you both.